Oh, you know what I got to do? I got to shrink this. Then I can see it. Good. Injunction. Let's share the injunction. People, let me know if you see the injunction right now. This might take a little bit of time to figure out just to make sure that I can see it. This court orders. Okay, so we're on the injunction. Let me go now so that I can toggle the document. Bear with me, people. Bear with me. Here we go. Okay, now I'm toggling it. So this is Ontario Court of Justice, the Ontario Superior Court of Justice, Provincial Court, Honorable Justice McLean. His name is McLean. Was it Ron McLean or Bruce? It's Bruce McLean. No, it's Bruce Willis who played. What's his name? McLean. Sean McLean? I forget. The lawsuit here, let's see, moving party, Zeshi Lee versus Chris Barber, Benjamin Dichter, Tamara Lick, Patrick King, and a bunch of Jane Does because they don't know who they are. Okay, so here you go. This is how it works. You go on an injunction. It's an incomplete file. Everybody files whatever documents they can based on the fact that it's necessarily an incomplete file because it's an urgent injunction. This motion made by plaintiff for an interlocutory injunction and costs pursuant to Section 1 of the yada, yada, yada was heard at Ottawa February 5 and 7 by video conference. Upon reading the records of the parties and upon hearing the oral argument made by counsel for the parties by Zoom, the court orders that an interlocutory injunction is granted pursuant to Section 101. Okay, that's the provision of law, I guess, under Ontario law that grants the injunction. This court orders that any persons having notice of this order are hereby restrained and enjoined from using air horns or train horns other than those on a motor vehicle of a municipal fire department in the geographical location anywhere in the city of Ottawa in the vicinity of downtown, being any street, whatever. So they geographically limited, temporally limited, 10 days, which would bring you to the next hearing. This court orders that the defendants, Barber, Dichter, and Lick, forthwith direct that they communicate this order through their social media, ordering the organizers to communicate this order through their social media and other channels to all persons who they know are or who have been participating in the Freedom Convoy. And I presume that is so that anybody would have notice of it, as per paragraph 2. Whether or not it has to be formal notice served by a bailiff, I don't think so. Someone in the chat correct me. If you know of an order and knowingly violate it, even if it hasn't been served on you by bailiff, I believe you can be held in contempt. Yada, yada, yada. This court orders that any police officer with the Ottawa Police, by the way, getting back to the Emergencies Act and whether or not it was necessary, whether or not the resources were unavailable at the provincial level, which required federal intervention under the Emergencies Act. Just look at this order here. This court orders that any police officer with the Ottawa Police Service and or the appropriate police authority in the jurisdiction in question, the police shall have authorization to arrest and remove any person who has knowledge of this order, and who the police have reasonable and probable grounds to believe is contravening or has contravened this order. So local police are empowered to, what does it say? Where does it say it? Arrest and remove anybody with knowledge of the order. So if they go to someone's phone and sees that they follow Tamara Lick and they see the post of the order and they saw that person honking their air horn or train horn, they could do it. They could arrest and, what did it say here? Arrest and remove. The provincial police can do this. The provincial courts authorize the police to do this as if the police needed court authorization to enforce the law anyhow, but to avoid ambiguity. The court orders that the police shall retain discretion, again, empowering the provincial police, necessary resources to deal with this national emergency. As to the timing, matter, enforcement order, yada, 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 irrelevant. This court orders, to detain and release any person without arrest who the police have reasonable and probable grounds to believe is contravening or has contravened. Let's read this. The court orders that the police shall retain discretion as to the timing and manner of enforcement of this order, and specifically retain discretion as to the timing and manner of arrest and removal of any person pursuant to this order, and to detain and release any person without arrest who the police have reasonable and probable grounds to believe is contravening or has contravened any provision of this order, upon that person agreeing in writing to abide by this order. You can detain them, don't arrest them if they undertake in writing not to violate the order. The court authorizes that any peace officer and any member of the police who arrests and removes any person pursuant to this order shall have authorization to release that person from arrest upon that person agreeing to it. Yeah. This court orders that provided the terms of this order are complied with, the defendants and other persons remain at liberty to engage in a peaceful, lawful, and safe protest. So that exists, and that predated by a long shot the declaration of the Emergencies Act under Trudeau. As we've noted, the criteria for which are that there is a national emergency for which the provinces lack the resources to deal with. What else do we care about that? I don't think we care about that. So I'm going to close. I'm going to shut. Do I want to shut it down? Shut her down. Okay. Did I just shut me down? Tell me I didn't shut me down. I didn't. Whew. All right. And I'll stop sharing now. I stopped sharing. So can you all believe that? That was the order. It basically said you can continue doing it so long as you respect the order, you can continue protesting and it would be lawful and peaceful. They stopped honking, I believe, before this court order was issued. And so, my goodness, when they come out and declare that it was an illegal occupation, there was no declaration of any court, there was no order of any court that said that this, call it whatever you want, that said, you can call it illegal occupation all you want. There was no court order that declared that protest illegal, nor was there any court order that proclaimed that it was an occupation. Sober second thought, that's what it's called. If Senate is a sober second thought check, why are we allowing Parliament to make decisions under influence? Touche. So that order was the injunction. And by my understanding, by the way, although it looked like a smashing victory for the petitioner, the plaintiff, and the media spun it that way. Oh, they got a court order. Apparently, they had asked for like everything under the sun in the injunction. It's typically what you do. The court cannot grant that for which you have not asked. Oh, the hua is now permanently ingrained in my brain. The court cannot grant beyond the conclusion sought. It's called ultra petita. The court cannot adjudicate ultra petita. You don't ask for it, the court can't give it to you. And if the court gives it to you, despite having not asked for it, the court has exceeded its authority. So they asked for everything under the sun as far as that injunction went, and all that they got was an order on the horns. So the media spun it as a crippling defeat for the protest. My understanding is it wasn't, and it only targeted the horns itself, which, you know, it is what it is and was what it was. But by all accounts, they had stopped honking anyhow, and by other accounts, although disputed, they had stopped honking at night regardless. They did not honk that way throughout the night. Although who knows what went on elsewhere with people honking, maybe just out of frustration. So, okay, good. I'm still here. Good. And I missed a chat, but here it is. So that was the injunction. And a lot of people were saying that the injunction effectively, the injunction did not declare the protest lawful because you don't need that. You would need a court order to declare the protest unlawful. And the court order didn't do that. The court order basically said, abide by the terms of this injunction and continue doing it peacefully and lawfully, and it's a peaceful and lawful protest.